Hello everyone, welcome to the Home Buyer webinar, and today we're talking about the rules affecting FHA flips. Let's look first at the definition and history of what a flip is from HUD's perspective. And of course, as you may know, HUD is Housing and Urban Development. It's the arm of the government that oversees FHA loans. Now, a flip in the real estate industry is the acquisition and the reselling of a property within a short period of time. Properties are usually flipped after some rehab or some remodel work is done, but sometimes they're actually resold with just zoning changes, paper changes if you would, and even that's considered a flip. Now HUD, which as I said earlier oversees FHA, has historically kind of frowned on flips because there were predators who were running around reselling properties at artificially inflated prices to unsuspecting buyers that were coming into the market. And so HUD laid down a 90-day rule called a 90-day no flip rule back in early 2003, and they stuck with it for about 7 years. That rule is the anti-flipping rule. It's also known as FR 4615. Now, early 2010, you could say in an effort to light a fire into the housing market, HUD temporarily lifted that restriction that they stuck with for about 7 years, and they announced that FHA financing can be obtained by buyers purchasing homes that had been owned for less than 90 days by the seller, but with some restrictions. And this is what we'll be discussing in this webinar. We'll be looking at those restrictions that HUD laid down within their waiver, if you would, of early 2010. Okay, flips of homes owned by the seller for less than 30 days. Now, these are prohibited unless the seller meets one of the following exempting criteria. The seller is a nonprofit agent approved by HUD that's selling homes at a discount. In fact, there's a roster that you can visit there. If you look at that long web address, go and click on that, and you can look at the list of nonprofit agents approved by HUD. If the seller is a government agency, such as a state government, federal, local, county, the seller is HUD itself, or the seller is a government-sponsored enterprise, such as Fannie Mae or Freddie Mac. Now, the seller can also be what's called a federally chartered financial institution, and that's a special designation that was given by the federal government all the way up to about 1992. Now, the federal government stopped issuing these back in 1992, so any such institution that's under that federal charter is in some way considered to be sanctioned by the government that recognizes that institution's role in society, and the government stopped handing out those labels since 1992, but nonetheless there are many federally chartered institutions around. Now, another exempting factor is if the seller acquired the home through an inheritance. So grandma gifted the property to a grandson. That grandson, when he sells the home, is not affected by HUD's flip rule. The seller might have acquired the home when an employee relocated. So that's not so common, but it does happen. The seller could be the lender or the middleman that lenders hire to deal with their, bank-owned properties. Those are also exempt. And finally, if the seller is an incorporated entity that buys foreclosed homes using the NSP program. The NSP program is a federally overseen program whereby federal money is filtered down to different agencies at state and county and even city level to revitalize areas of the country that need help in terms of the housing market. And if the seller is an incorporated entity that buys foreclosed homes using that program, then that seller is exempt from the rule affecting sellers that have owned the property for less than 30 days. Now, let's take a look at flips of homes owned by the seller for between 1 and 90 days. If the seller is reselling for more than 20% profit, in other words, if you look at the acquisition price the seller got the property for, and you look at the resale price, if the resale price is more than 120% of the acquisition price, then there are some additional restrictions imposed on the seller. If the seller is trying to sell between 1 and 90 days of owning the property. Here's an example. The seller purchased a home on May the 7th for $140,000, and they've got a contract to resell that property to a buyer off, on an open market, dated the 1st of August for $200,000. Now, the profit is $60,000. If you get a little calculator and you take $60,000 and you find out what percentage of $140,000 that is, then you arrive at the figure 42.87%. In other words, the profit there is 42.87%. Now, since the profit is $60,000, which is 42.87%, the following restrictions apply. Now, the seller has to either document, using receipts or contractor bids, so on and so forth. Document the type and the cost of the work that was done to warrant the increase in price, or a second appraisal has to be ordered by the lender, which cannot be paid by the buyer. So the second appraisal cannot be paid by the buyer at the time of being ordered. Now, the buyer can reimburse the lender at closing for that second appraisal, but at the time of being ordered, that second appraisal has to be paid for by the lender. Now, in addition to the above, a property inspection must be included in the file, and that property inspection has to be ordered and paid for by the lender, not the buyer. The buyer can reimburse the lender at closing, but at the time of order, the property inspection has to be paid for and ordered by the lender. And secondly, a fully executed property inspection certification must be included in the file. So you can see how HUD's going to impose some additional restrictions just to cover all their bases in the event that the seller's reselling the property for more than 20% profit. Now, who's exempt from that 20% rule? Sellers who were listed as exempt from the less than 30-day rule are also exempt from the more than 20% profit rule when they're reselling the property within 90 days of acquiring it. Now, that was a mouthful, so if you don't understand that, go back and listen to it again. Let's look at flips of homes owned by the seller for between 91 and 180 days. Say the seller is reselling for more than 100% profit within 180 days, the following apply. A second appraisal will be required, again, to determine the viability of the home's resale price. You know, is it reasonable or is it artificial? And that's irrespective of the selling entity's exempt status. There has to be a second appraisal. Now, to avoid this, the seller can provide proof of the amount they actually paid for that property at the trustee sale, or if you're in a mortgage state, a judicial foreclosure sale. Now, for example, if the seller proves they bought the home for, say, $90,000 at the auction and is reselling it for $170,000, a second appraisal would not be required since the resale is not over 100% of the acquisition price. If you look at $90,000 over $170,000, that difference, that spread, is not 100% of $90,000. So the seller can get away without a second appraisal. Now, if the appraised value from two appraisals is not identical, which is likely, I mean, it's unlikely that both appraisers independently would come up with the exact same figure. If that's the case, the FHA loan amount for the new buyer must be based on the lower of the two appraisals. So again, there are some restrictions, you know, as far back as 180 days from the acquisition of the property. You know, the seller might think, wow, I'm far gone, I'm in the clear, I'm out the woods. Not the case. If there's 100% profit on the resale, even up to 180 days, there can be a second appraisal required. And there will be if the acquisition price compared to the resale price shows 100% spread. Now, let's take a look at some additional stipulations for properties that have flipped within 90 days. Okay, the transaction must be an arm's length transaction. In other words, that there cannot be what's called an identity of interest in FHA lingo, an identity of interest. The seller and the buyer cannot be known to each other. For example, you can't be family members selling from one person to the other, or even an employer that's known to the employee. That will be prohibited as well. That's not an arm's length transaction. So if there's a 90-day flip going on, it has to be from a bona fide buyer, you know, off the street, so to speak, that doesn't have a prior relationship with the seller. The geographic areas that are declared as presidential disaster areas are actually exempt from the flip rule. Obviously, in recent times, Louisiana and a lot of the surrounding states that were affected by Hurricane Katrina would be eligible to be considered a presidential disaster area, and then wouldn't be subject to the 90-day flip rule. Now, the 90-day flip rule has never been completely eliminated by HUD. You've got to make note of that. It has never gone away. All we're doing is we have, as of the time of this recording, in late 2011, 2012, we're just in a temporary waiver period during which HUD lifted the rule to sort of allow the housing market to breathe, to come up for air, if you would, because the 90-day flip rule has been very restrictive and made it very difficult for investors to operate freely in the market and replenish their investment funds and go on to the next property. So it really was a tightening effect on the housing market because folks that needed to buy a home with FHA financing could not purchase a home if the home had been owned for less than 90 days. So now we're in a waiver period, but HUD has not completely eliminated that rule. And I, as an originator, as a mortgage professional, am pretty certain that when the housing market recovers, HUD will reimpose its original rule. Who knows? Meaning of the acquisition date. Let's take a look at that. The acquisition date is best defined as the date the seller was granted title and not the date a deed was recorded. There is a vast difference. For example, the seller may have paid cash and received title on June the 5th, but the notarized deed didn't hit the county records until June 25th. Now, the acquisition date for figuring out a 90-day rule is June 5th, not June 25th. If you're talking to your lender, you don't want to lose 20 days because your lender is going off of the more recent date, which is the date that the deed was recorded. Technically, by our rule of law, that seller became the rightful owner of the property when the deed was notarized and given to him, not just when it was recorded. Let's take a look at the meaning of resale date. The resale date is the date of the contract with the new buyer and not the date of closing of the resale transaction to the new buyer. Now, here's an example. Say the contract date is April 9th, and say the closing date is supposed to be May the 9th. A lot of lenders, real estate agents, buyers might think, okay, May the 9th is the closing date. The seller can have acquired the property as recent as February the 9th, and that's not the case, because we start with the contract date and go back 90 days. So from April 9th, going back 90 days, that seller could not have acquired the property or should not have acquired the property any more recently than January the 9th. It might sound a little convoluted, so if you need to go back and listen to that, feel free to do so. Now, the seller must be the owner of record. This means that lease options and a lot of these subject to investor approval flips where somebody might try to assign a contract, those will not work with FHA financing to do with the 90-day rule. A lot of investors will acquire a property, not even close on the property. They have a written document called an assignment of contract, and they'll go turn that contract over to the actual investor that's going to fund that closing. Well, that doesn't work with the 90-day rule. The owner of record has to be the seller, and the seller must be the owner of record. Let's talk about lender overlays. We've gone over what the true HUD FHA rules are regarding flips where properties are being resold for profit within a short period of time, 30, 60, 90 days. Each lender that does fund FHA loans has its own set of overlays. In other words, not all lenders are going to stay true to HUD's ruling. Obviously, they can't be more loose or more lenient than HUD's ruling. Otherwise, they couldn't turn that closed funded file into an FHA insured loan. So the only direction we can go is the lender might become more stringent and more restrictive than HUD really is. So a lot of lenders will either flat out not do 90-day deals. In other words, they flat out will not do any loans where the seller does not own the property for more than 90 days, or they may not allow a 20% profit from the seller, regardless of whether there's a second appraisal and regardless of whether the seller has proven and justified the reasons for the increase in value. A lot of lenders will not do those loans. So when you're talking to your lender, be sure to ask them up front, hey, what are your overlays, if any, with regard to the 90-day flip rule? Thanks for watching, guys. I hope you found this helpful. There are several other home buyer webinars that are on our blog and our YouTube channel. Always feel free to call or email with questions. And thanks again.